And we were left with the sense that we have made so little progress as a country in combating centuries of systemic racism. And the historic protests here and in all 50 states highlighted the need for structural change to our policing system. Even as Washington enacted increased accountability measures with the passage of I-940, there are still issues that need to be addressed. And as state lawmakers, we watched our communities fight for change, and now it is our responsibility to respond with action. And that's what compelled me to be here before you today. And this topic of arbitration and collective bargaining, like so many things in the legislature, is not as simple as it seems, but through many hours of discussion with stakeholders in labor, law enforcement, and families impacted by police violence, we've crafted a thoughtful and measured approach to address systemic issues in the arbitration process for law enforcement discipline. This bill streamlines and reduces bias in the arbitrator selection process. It increases transparency of arbitration decisions, and it addresses the intersection between local ordinances and union contracts. But I want to be clear that we can respect the work that local jurisdictions are doing with their communities while also respecting the rights of workers to bargain over the impacts of those community-based decisions. We also know that by improving our policies one by one, we can start to make a difference and offer hope to a community in need of healing and desperate for change. I urge your support and thank you for the time.
Thank you, Senator Nguyen, for the testimony of the bill, for the reason for the bill. I have a question. One other thing you didn't mention. Does this bill also have a provision? I believe we have an ability to get a better set of data about what the outcomes really are of these processes, because it seems very anecdotal right now.
Yes, thank you, Madam Chair, for that question. So right now, as we were doing research for this bill, we were trying to get more data as it relates to arbitration in Washington State. Unfortunately, there's not a consistent method to collect that information in Washington. Some jurisdictions do it different. So part of this is by having it centralized under PERC, we will be able to actually see what that looks like in Washington State, which we can't do right now.
Great, good to know that. I see Senator Conway. Is your hand up still from before or now?
No.
Go ahead.
I guess, I actually like this bill because it's expanding the authority of PERC to oversee these arbitration decisions. And in fact, that's a thought that I had very early and talked with PERC about this. But the issue that concerns me is probably the issue that restricts the collective bargaining agreement's ability to look at disciplinary issues, even though currently that's a mandatory subject to bargaining. And I guess what I'm concerned about is your thoughts on that language, Joe. I guess I just have some concerns that I think there's an area of discipline that we might be looking at, but seems like that language is pretty broad.
I think you refer to Section 4, Senator Conway, and I think that specifically so that local jurisdictions also can have their decisions be respected as well. I'd be happy to offline to clarify what that means, or if staff is able to jump in as well. But I think I know which section you're referring to, and we can chat.
Well, I like this bill because I think it does address a need to expand the authority of PERC to look at to look at arbitration decisions. But I'm a little concerned about the breadth of that language and look forward to working with you on it.
Perfect, thank you.
Excellent. All right, it looks like we'll have some more conversations on that. And if there are no other questions at this point, I'll call the first panel of electeds who have signed up to testify on this bill. So if we could please get into, I don't know what we call it, the box, I guess. Mayor Jenny Durkin from Seattle, Mayor Victoria Wooders of Tacoma, Council President Brianne Beggs of Spokane, pardon my early morning eyesight, Councilmember Lisa Herbel of Seattle, and Commissioner Colleen Echo Hawk with the Seattle Police Commission. Now that's 5 individuals. Are they all in place here? Can we begin with Mayor Jenny Durkin? I'm not seeing, I need a
I
gallery.
think I'm seeing them. It's just a little bit delayed this morning.
Yeah, it is a little slower today. I see her too, so I'm sure she'll get online. I guess it's.
Thank you, Madam Chair. I think I see myself now, so I appreciate.
We see you too. Thank you.
Thank you, Madam Chair, and thank you, Senator Conway and other members of the committee for allowing us to testify here this morning. I also want to take a moment to thank you for your service. We are serving in incredibly challenging times, and just the way we're arrayed today, in a global pandemic, at a time when there is great political strife across our nation, it is even more important for government to continue. And I know that each of you senators is doing so under extraordinary, challenging times yourselves. And it's your collective wisdom as citizen legislators, bringing together, whether you're a wheat farmer or someone who's been like you, Madam Chair, brought us great workers' rights forever. So I just want to thank you so much for your service during these times. And I think this bill today shows that we can come together to make changes in the law that serve communities across our great state. I want to thank Senator Wynn, Senator Solomon, Senator Saldana, who have worked closely with us on these bills. And I support this bill because I think it is important to have greater consistency in arbitration to have confidence of the people. I'm also hoping that at some point that this committee and the great bodies consider additional protections. I want to make a few things clear. Is one, I stand with workers and believe strongly in collective bargaining rights. I was a union member myself, was a Teamster. As the mayor of Seattle, have been fortunate to work with Councilmember Herbold and others who you'll hear from to make sure that we had new protections for domestic workers and Uber drivers. I've also stood on picket lines. I also believe that police have an incredibly important function for our society. We saw last week how the Capitol Police stood bravely to protect government and our systems of democracy. And they do that in every day in communities across our great state. But with those awesome duties and responsibilities also come the need to make sure that we have protections because they can take liberty, they can take life, and that happens in their jobs. In their collective bargaining rights, when we're looking at discipline, it is so important that that discipline also make sure that the communities know that they will be held accountable and the systems and policies in place when officers do things that they are disciplined for. It is a rare case when a police officer is terminated or gets significant discipline in a case. And it's important to them and their fellow officers that the chief or sheriff, when giving discipline, that there's certainty with that discipline for confidence and for accountability. Police departments and sheriff's departments act almost like paramilitary. The chain of command is critical. It is very dissettling to community and to officers if the decisions of a sheriff and chief can be overturned by an arbitrator without good cause. We need more certainty in that process. We need to make sure that when an arbitrator hears a case, which is a due process right given by the state, that they do so based on the same evidence that the chief or sheriff looks at, and that they do not have an entire new hearing, that they are able to maintain, because every officer looks at what happens in discipline. So I support this bill. I support the other things that Senator Solomon is trying to do. We are seeing so many bills across this great body, the Senate and in the House, that will give us greater accountability to answer the things that Senator Wynn so eloquently stated in his testimony. I'm proud to be here with my good friend, the mayor of Tacoma, with Mr. Beggs from Spokane, and with the community members who will testify, because it is time for us to answer the calls to make changes that both protect community, protect officers, but also give us the certainty we need in this area of the law. So I thank you for this opportunity to speak.
Thank you, Mayor. And we will hold questions till after the panel is completed. Mayor Victoria Woods from Tacoma. I know I saw your name. There you are. I see your face.
Ma'am, good morning, everyone. What an honor to be here with you this morning. to Chair Kaiser and my Senator, Vice Chair Conway and Stanford and Honorable Senators. I'm Victoria Woodard of the City of Tacoma, and I'm here today to speak in support of Senate Bill 5055. I also want to thank Senator Nguyen and those who worked with Senator Nguyen to bring this forward. I want to begin this morning by stating that I truly believe that law enforcement officers are dedicated public servants, and their work is crucial to ensuring that our residents can feel safe in our communities. I also want to clearly state that the City of Tacoma's position on arbitration of disciplinary decisions that I'm expressing here today specifically pertain to law enforcement officers only. Police officers have a unique authority in our communities. That is the reason why we are interested in the review and reform to the arbitration process. We honor the hard work of law enforcement officers while also acknowledging that as policymakers, local and state elected officials can only and should continue to review and improve upon the systems in place to ensure police accountability. Senate Bill 5055 takes an important step in the right direction by providing for arbitrators to be appointed by the Public Employees Relation Commission. I believe that the training requirements outlined in the bill would enhance an arbitrator's ability to make sound decisions that could have significant consequence in our communities. Arbitrators should absolutely have training on cultural competency and implicit bias, in addition to education on the daily challenges and unique circumstances that law enforcement officers can face in the field. I would respectfully offer that this legislation could be strengthened by adding some additional provisions that would help safeguard law enforcement agencies' ability to manage their workforce and discipline or terminate officers as necessary. Decision on appeals of disciplinary decision should be based on the same record that the law enforcement agency considered when making the disciplinary decision. New information should not be introduced unless it is crucial to the case and was reasonably available at the time the disciplinary decision was made. Arbitrators should be given deference to the disciplinary authority when hearing police disciplinary cases. As many collective bargaining agreements dictate, a progressive discipline process is followed to identify and improve an officer's performance if there are issues that need to be addressed. By the time an officer is terminated from employment, there have been often several breaches of policy or serious incidents that warrants the disciplinary action. The burden of proof should be an overall preponderance of evidence that the disciplinary action was for cause. Lastly, hearings, not just decisions, should be recorded and made available via public records request. Community members have a right to hear those proceedings to fully understand the situation and the evidence that was considered in the decision. This level of transparency would help build public trust, and we all know public trust needs to be built. In summary, this legislation provides for improvements to the arbitrator selection process that Tacoma supports. And we would ask that consideration be given to adding some additional guardrails that would help law enforcement agencies properly manage their workforce. I thank you for allowing me to be here today and for hearing my testimony this morning.
Thank you, Mayor. And I'm going to have to become disciplined now about time because we really do have to have time for everyone to speak. If you have prepared remarks, please submit prepared remarks to staff so we can read them at our leisure, but just please keep your testimony to 2 minutes now, if you would. I'd like to call, please, Council President Breen Beggs from Spokane now. Welcome.
Thank you so much, Senator, for allowing us to testify from Spokane. And also special thanks to Senator Nguyen for bringing this forward. Spokane has been grappling with police reform for many years. Back in 2006, we had a fairly horrific incident of an innocent, unarmed person who was beaten and killed over several minutes. And it happened to be captured on video, which led to some serious changes. And our police department has made terrific changes working with the Department of Justice, and our current chief and union are committed to reforms. And so we appreciate that. But one of the things we wanted to do back then, and we've struggled with despite 70% of our voters approving a charter amendment, is allowing meaningful civilian review of disciplinary proceeding. And I want to clarify that in Spokane, what that means, it's an ombudsman theory or ombuds theory, which is the person doesn't have an impact on disciplinary decisions, but they get to observe the investigation and they get to file a report at the end of it so that all the community members know whether it was a thorough and objective process. And ideally, and the part we haven't gotten, is to tell us what happened in the incident. Because our theory is that we have to take a model of harm reduction. The ombuds and the civilian review is not about disciplining, it's not about finding fault, it's how do we prevent harm in the future. And state labor law has really gotten in the way of this. We've had laws on the books for 12 years now, but we still have not been able to fully implement the Citizens Charter Amendment. And so this Section 4 is so important to us that as long as we're not impacting directly disciplinary decisions, civilians can be involved in understanding what's going on and getting a full report from their representative, the ombudsperson. So I rise in support of that. I love the rest of the bill as well. We support our officers here and throughout the state, but this is really important because when they created labor law, they didn't imagine an ombuds process that wasn't part of the discipline, but could provide full reporting to the public. And given the shortage of time, I'll stop there. Thanks so much for your courtesy.
Thank you very much. I really appreciate your viewpoint. Lisa, Councilmember Herbold.
Good morning. Appreciate the opportunity to be here. I'm Lisa Herbold, Chair of the Seattle Public Safety and Human Services Committee. I thank the sponsors of both Senate Bill 5055 and 5134. In Seattle, we have an appeals backlog, 80 and growing, with misconduct findings of the chief challenged. Some unresolved cases of misconduct from 5 years ago. In 2019, we only resolved 2. I believe thorough discussion of both bills can lead to enhanced public confidence in police. Seattle's state legislative agenda supports both reform of arbitration and removing private arbitration in law enforcement discipline. In this spirit, I support both bills. On Senate Bill 5055, I support standards that benefit jurisdictions outside of Seattle and with amendment, potentially benefit Seattle, if including appeals deference to the chief's decision in the original discipline, appeals based on the same record as the discipline imposed, requiring a preponderance burden of proof in appeals, and a duty to record hearings. If outright elimination of arbitration is not the path forward, I request that elements of Senate Bill 5134 be considered and recognize, as it does, that policing is unique due to discretion to engage in state-sanctioned force, taking of life, and taking of liberty, and prohibit collective bargaining agreements from requiring waiting periods for misconduct interviews, allowance for secondary employment, time limits on complaint filing, limits on use of civilian supervisors and investigators, and limits on use of subpoena authority. Thank you so much for your time this morning, and thank you again to the bill sponsors.
Excellent. Thank you so much. Commissioner Echo Hawk, if you'd like to speak.
Good morning. Thank you so much for allowing me to be here. I am so in support of Senator Nguyen and grateful that for the leadership. I just want to acknowledge that there are many family and friends who are in pain this morning, who are experiencing ongoing trauma because of us trying to get to a good spot to hold police accountable. And I just wanted to acknowledge that this morning. I know my heart was hurting when Senator Nguyen read all of the names, and I just think it's important for us to remember that. I am honored to be here. My name is Colleen Echo Hawk. I'm a commissioner with the Seattle Community Police Commission. We are a diverse group of community leaders created to amplify and create space for community's voice in the police accountability process. Among our ranks are faith leaders, BIPOC organizers, law enforcement members, and union members. Most importantly, we love our community. That's why we're there. We show up every week to love our community and support them. One key way that accountability for police misconduct is undermined is through flawed and broken arbitration systems. We have seen the devastating effects, that broken arbitration systems has had on BIPOC communities here in Seattle. There have been instances where officers' discipline is unjustly overturned by arbitrators, which ultimately denies justice for those who have been the victims of police misconduct. Current arbitration laws lead to a process that is not transparent to community and unjustly denies victims of police violence accountability. The CPC has spent years cataloging problems that the community has found with arbitration and has submitted a document outlining those problems to this committee. For these reasons and more, we as a commission support the complete removal of arbitration as a route of appeal for police misconduct. At the very least, Washington laws need to be changed to address the many problems arbitration currently poses. The stakes are too high, especially for my brown and Black relatives. Like no other profession in our society, police are given authority to take people's lives and deprive them of their liberties. Police need to be held accountable. Not doing so puts the lives of our BIPOC communities in danger. So thank you so much for your time. It's been an honor to be with you.
Thank you, Commissioner. I see Senator Conway, your hand is up.
Yeah, Lisa and Colleen both have references a list of arbitration decisions that have been wrong, and I just want to see the list. That's all, and see the type of disciplinary problems that were overturned by arbitrators. Thank you.
That would be helpful information. If you could give that to staff, that would be great for us to be able to review it. We're not all in Seattle.
It's included, I believe, in our documents.
Thank you. Thank you very much, and I appreciate your comments. Senator King has a question.
Thank you, Madam Chair. I really don't have a question. I just want to thank all of those that came to testify today. And I thank Senator Wynn for bringing the bill forward. I think it's something we need to look at and talk about. But I would be remiss if I didn't say that, you know, our laws are for all and they need to be enforced equally for all. And when police are hindered in some cases from enforcing our laws, I believe, and protecting the public, I believe that that helps create some of the problems that this bill is trying to address. Just wanted to say that. I appreciate the opportunity, and thanks for everybody's testimony.
Excellent. We're going to go into our next panel of individuals representing different elements of the labor community. Joe Kendo with the State Labor Council, Marco Montalblanco with the, I believe it's the Fraternal Order of Police, Samantha Grad with United Food and Commercial Workers Local 21, and Monisha Harrell also with Equal Rights Washington. If you could come get into position. Joe, I see you. Go ahead.
Thank you, Senator Kaiser and Senator King for providing me this opportunity to speak today. My name is Joe Kendo, and I'm the Government Affairs Director here at the Washington State Labor Council. And today I'm testifying as other. First, I just do want to thank Senator Wynn for the extensive stakeholdering he did on this bill. And I know he listened to a lot of voices and gave this proposal a great deal of thought. And I think it is better for it. You know, grievance arbitration is almost a sacred thing in the labor community, as it's what allows us to move past an intransigent employer to seek informed third-party decisions in disputes over the interpretation of our contracts. And obviously that is a very important notion for unions everywhere. We believe the vast majority of the content of this bill is good, and think the emphasis on knowledge of cultural competency, racism, bias, and community values for the selection of arbitrators is really important, and it's only strengthened by requiring further training of arbitrators by PERC. The only hesitance we have with this bill as written, and the reason I'm testifying other and not pro today, and it is potentially a significant problem, is the risk of limiting the pool of arbitrators available to resolve this disputes. And I think that will probably be brought up in later testimony. You know, in anything that causes further delays in conclusions in arbitration does not serve anybody. It doesn't serve management. It doesn't serve the the officers. It certainly doesn't serve community. And I do believe that should be addressed. But otherwise, I think this bill is a great bill, and thank you so much for your consideration.
Thank you. I see Samantha's up and running. Go ahead, Samantha.
Thank you, Senator Kaiser and members of the committee. For the record, my name is Samantha Grad, Political and Legislative Director for UFCW 21. I'm here testifying in support of Senate Bill 5055 and proposals to strengthen provisions to ensure law enforcement accountability for violence in our communities. We're really committed to working with you, impacted families, communities, leaders, and lawmakers to end the violence present in police culture and practices. You're going to be hearing a number of different proposals this session, all of which are critical steps to changing the toxic and deadly culture we have. And addressing the appeals process is a critical step to ending police violence. We know that police hold state-sanctioned power over life and death. They have the power to de-escalate or escalate crises. They have the power to treat those they suspect of committing crimes with dignity, to safely stabilize dangerous situations safely and humanely. And when police choose violence, they must be held accountable for that. The ability for meaningful consequences is a key part of motivating police departments and their employees to make the changes necessary to undo years of implicit racism and to stop police violence. Senate Bill 5055 ensures that civilian review of discipline may not be eroded or undercut by collective bargaining agreements, but also creates clear guidelines and procedures to ensure that if a discipline action goes to arbitration, the arbitrator is qualified, trained, and follows specific guidelines, and that there is accountability and oversight of those arbitrators. You're going to hear from people today, and again with other policies, that there might be additional ways that these processes can be strengthened to fortify responsibility for officers who've been terminated, suspended, or demoted for significant violations. We agree there is more to do. Ensuring uniformity and predictability in how arbitrators will review discipline, what evidence will be reviewed, and creating transparency in the process are all important steps towards meaningful accountability. This level of real accountability is a necessary step towards eliminating police violence. We appreciate the work Senator Wynn and the many, many people working to address police violence have done this session and will do, and stand ready to help in any way we can.
Thank you, Samantha. Marco, I see you're up, and if you'd like to speak.
Thank you, Madam Chair and members of the committee. My name is Marco Monteblanco, and I'm the president of the Washington State Fraternal Order of Police. The Fraternal Order of Police represents here about 3,000 members statewide. We are the most diverse law enforcement organization around, as we accept membership from all facets of law enforcement to also include tribal officers. Because of that, we do consider ourselves that one voice for all law enforcement personnel. I'd like to take a quick moment before I begin my remarks just to say something positive about law enforcement, something that we do when we testify. I want to recognize one of our officers in the Kennewick Police Department by the name of Sebastian Castejea. He recently organized a program which received donations, monetary donations for children in need, which provided gift cards for their families. He took it a step further with working with others to get monetary donations for food for families during the holiday. And it's that type of selfless service that I really appreciate in our officers, and I'm proud to call him my brother in law enforcement, but also my brother in the Fraternal Order of Police. And I'd like to take begin my comments by saying that we should start, from a perspective that nearly every peace officer in this state strives to have the trust of the communities they serve. We've heard this in previous testimonies in the other body, and we believe that the vast majority of law enforcement officers do their job with honor and respect for the profession, and that we should approach policy discussion in that light. That being said, in regards to Senate Bill 5055 presented by Senator Wynn, we do support this legislation for several reasons, and here are just a few highlights, high-level points why we support it. Number one, there is no central repository for arbitration decisions in Washington. Having a single place for law enforcement agencies and their officers, employers to arbitrate their disputes creates that single point for that purpose, and we can use this data to better inform future policy and management decisions. Number two, inserts a level of consistency that doesn't exist today when arbitrators are chosen outside of the PERC process. And lastly, we agree with the prime sponsor, Senator Wynn, that this bill respects workers' rights to bargain and arbitrate over the impacts of the adopted policies that impact their work environment. Thank you.
Very much. Manisha, go ahead, please.
Thank you, and I thank you for allowing me to address the committee today. My name is Monisha Harrell, and I'm the board chair for Equal Rights Washington. I am speaking in support of Senate Bill 5055. Martin Luther King had said, true peace is not merely the absence of tension, it's the presence of justice. And so as we start out this legislative session, I just want to commend you as legislators for taking up the work of addressing police accountability. Washington State has been a leader on many, many things. And I think truly understanding that it's not just about the absence of tension, but the presence of justice is something that Washington State and Washingtonians understand and have been working towards. And I thank you very much for that. We talk about culture and we talk about accountability, but we take away chiefs and sheriffs' ability to set both for their police departments when we take away their power to set discipline. And that's really what it comes down to. We want culture and accountability, but we don't allow the people leading that culture and that accountability the tools that they need in order to be able to set that. This bill will significantly help with those impacts. Arbitration is still in place for review of cases, but officers don't get two bites at the apple in terms of a fair hearing. They will have a fair hearing and they will have a chance for review of those facts of that initial hearing, which means that hearing that they are given, that is not taken away from them. But what we're taking away is the ability to have a completely new hearing once they hear the facts against them. So I just encourage us to support and pass this bill. It is really, really smart legislation. It doesn't touch the abilities to bargain salaries or working conditions, but we have to put some value on public safety for our communities, and that is why we stand in support. Thank you so much.
Thank you all for participating in this hearing. I don't see any questions or hands raised, so I'm going to move to another panel, which is not quite so supportive of the bill. And that panel is Theresa Taylor with the Washington Council of Police and Sheriffs, Dennis Lawson, Washington Council of Firefighters, and Michelle Woodrow with Teamsters 117. So let's see if I see, Theresa, I see you. That's one to start. Hi, please unmute we'll get you unmuted, Theresa, and get you going. Thank you.
Good morning, Chairman and members of the committee. Thank you for the opportunity to be here. I'm Theresa Taylor, the Executive Director of the Washington Council of Police and Sheriffs. Law enforcement is a profession in constant training, reform, and improvement. We are proud of that culture and proud of the professional services that are provided to our communities. Law Cops, unfortunately, is here today in opposition to Senate Bill 5055. The long and respected labor protection history of Washington State is important to all employees, including public employees in law enforcement. But because of those well understood labor practices, relationships between labor and management are for the most part very positive in this state. This bill would limit discipline-related arbitration to 9 pre-selected state arbitrators. We are concerned, as others have mentioned, that such a limited number of arbitrators may have difficulty managing the workload. We also are concerned that with such a special pre-screened group of arbitrators, that bias could be generated as they attempt to remain on this exclusive list. Current arbitration processes are well balanced. We know that management prevails in about 50% of arbitrated cases. That seems a testament to an appropriate and well-balanced system. This proposal would tip the scales away from workers and towards management. Though we oppose the mandates of this bill, we would support language that would require the Public Employee Relations Commission to be a clearinghouse for discipline-related arbitration decisions. If PERC were to house those decisions, we believe future discussions regarding arbitration policy would be better informed. We are concerned about the broad title, as has been previously mentioned. We do look forward to working with the Prime and this committee in the coming weeks, and we very much appreciate Senator Gwynne's efforts to communicate and talk with us openly about his proposal. Thank you for the opportunity today.
Thank you, Theresa. We will hold questions until after this panel is over. And Michelle Woodrow, sorry.
That's okay. Good morning, Chair Kaiser and members of the committee. For the record, my name is Michelle Woodrow. I am the President, Executive Director of Teamsters Local 117, and we represent over 17,000 workers in Washington, which includes law enforcement workers. And I am here today testifying on Senate Bill 5055. We appreciate the intent of Senator Wynn's legislation in its current form, and in concept, creating a pool of arbitrators that have experience and training handling arbitration for law enforcement is fine. And in practice, this is something that already happens over the course of regular arbitration selection. All parties share a common interest in selecting qualified arbitrators to resolve law enforcement issues. Our concern is that the pool of arbitrators could shrink, which could further delay the resolution of cases. Additionally, we believe that most arbitrators would not have any difficulty meeting the additional requested requirements as outlined in the bill. But again, we have concerns that the qualified pool will need special attention to ensure that there are always enough individuals to meet and maintain the caseload. The last concern that I want to put on the record is more process oriented. We are going to hear a lot of testimony today, and I believe that the broad title of this bill could allow the legislation to be changed substantially. Teamsters Local 117 would oppose any version of a bill that eliminates access to collective bargaining rights and arbitration for law enforcement members. Law enforcement personnel are workers. We believe workers deserve access to collective bargaining and arbitration. And for those reasons, we are signing in other. Thank you for your time today.
Excellent. Thank you, Michelle. And Dennis, welcome.
Good morning, Senator. Thank you for the committee, and thank you for Senator Wynn bringing forth this important issue. My name is Dennis Lawson, President of the Washington State Council of Firefighters, proudly representing 8,500 firefighters, paramedics, and EMTs across our great state. It is our hope that we as human beings can do better and do better, and I understand the importance of this issue. As somebody out on the front line every day working in the community, I too also see what is taking place. Our group unfortunately rises at this time in opposition to this bill as presented. We understand that there are things and there's components of the bill that do make sense. And as just recently just mentioned, as a worker, as a labor representative, we struggle with the fact that this appears to be an attack on the worker rights, the collective bargaining process, arbitration process, and that is the reason why we stand in opposition. The issue really at the forefront is discipline. Discipline in itself is a mandatory subject of bargaining. It is required by the employer and the employee group, to go through a process where we can actually engage in meaningful dialogue. And at the point where we cannot come to a resolution, an arbitrator could be selected. And in this case, when we talk about discipline, it's meaning that we're going to push it off into another group as identified as PERC. As mentioned, I also have some concerns regarding the 9 individuals, the rotation, the selection process, the training. As arbitrators are selected right now, both parties get to strike names. In this case, it would be done alphabetically. And unfortunately, you could end up with somebody that you may or may not wish to have, which is the case we currently have right now. We are willing to work with the groups to be engaged in the process. And I want to make sure that everybody understands the issue that we're dealing with is important. It is critical to our communities and critical to human nature. We have to do better. Thank you for your time.
Thank you, Dennis. Now, the final 2 people we have for this bill are Candace Bach with the Association of Washington Cities and James Mcmahon with WASPIC. I believe both are in the house and we'll find them soon. I see Candace is here and James. Go ahead.
Thank you very much, Chair and members of the committee. Candace Bach, representing the Association of Washington Cities, here in support of Senate Bill 5055. Thank you to the bill sponsors and to the committee for bringing this bill forward. We think it's an important part of the conversation about transforming policing in Washington. We, as has been noted, we have some remarkable law enforcement public servants in our state, and we think that the changes in this bill will serve them as well as the public for the better. And we know that this is part of the conversation that can get lost in some of the higher profile discussions that are going on, but we think that this is critical. The disciplinary process is a foundation of accountability, and we think that these changes make that process more consistent, more predictable, and more accountable to the public, to the officers, to the chiefs, to the locally elected officials that oversee these departments. This statewide approach is going to ensure more trust in that process. I do want to support the suggestions of the mayor of the city of Tacoma that we believe would strengthen this bill. Those things that would enhance transparency in the process and again, strengthen the public accountability here. We agree with some of the comments about 9 may not be enough, and providing PERC with some flexibility to scale that number would be an important way to address some of those concerns. Overall, we're worried that there's a loss of confidence in this process of arbitration. And when there's a loss of confidence, people don't use the disciplinary process the way that they should for accountability. We think that this bill is an important step in improving this process and in transforming our law enforcement in our state. Thank you so much for the opportunity to testify today.
Thank you, Candace. James, go ahead.
Good morning, Madam Chair and members of the committee. I'm James Mcmahon, Policy Director with the Washington Association of Sheriffs and Police Chiefs, pleased to testify in support of Senate Bill 5055 today. I think it's important to note that nearly every one of the 11,000 Washington law enforcement officers conduct their public service as law enforcement officers exactly the way that we all would expect them to do. And they deserve credit for their public service and their countless selfless acts that we will never hear about. However, so long as we employ human beings to do those jobs, we must expect human behavior, including stress, anxiety, exhaustion, and yes, misconduct and even criminal acts from time to time. It's important that sheriffs and police chiefs are empowered to act in the rare occasion that the misconduct of our officers occurs and warrants discipline. Failure to do so erodes the public trust in this sacred institution. However, it's our experience that other factors outside of our control can also have that same effect of eroding public trust in our law enforcement institutions. And we find one of those in our current system of arbitration. Now, the data is hard to find, and you've heard some of that already, but about half of Washington arbitration cases get upheld and about half are overturned. We find that factor at the heart of the objectivity concerns that we have with our current system. You see, and you've heard it before, arbitrators now are selected, usually a list of 5, and arbitrators are removed from the list with vetoes from law enforcement management and labor groups. And we think that there's a personal financial incentive for an arbitrator to split the baby, so to speak, rule about half in favor of management and about half in favor of labor, rather than issuing rulings that are based on fact and public policy. For those reasons, we support Senate Bill 5055, and we concur with the recommendations to not have a static list of 9 so we can accommodate for the caseloads.
Thank you, James. And I see no hands raised at this point. We have one individual person who signed in with us today, Kathleen DeSmet, who is from the island of Vashon. Kathleen, are you still with us?
Senator, she is no longer with us.
Okay. I'd like to also mention that Dario De La Rosa, who works at PERC, is available if anyone has any questions with that you would like to pose at this time or not. Senator Conway.
I would, my ask is that if PERC could comment on this bill. This is a major bill impacting them. I'd prefer to hear from them if they're available to talk.
Dario's in the house if you have a question for
Yeah,
him.
my question is does this bill fit their needs and will it incur any additional costs for them?
Senator Conway, there will be, Dario Della Rosa, I'm with the Public Employment Relations Commission. Executive Director Sellers apologizes for not being available today. There will be some additional costs associated with this bill, but those costs will be fairly minor. The training component, we figure that we will need on a one-time basis some additional staff time to develop the training that would be required of the arbitrators. Additionally, we'll have approximately about $5,000 annually for additional website use associated with publishing the arbitration awards on our website. We would be putting those on our searchable. We have a search engine for all of our decisions. So, it's our intent that the decisions would go there so that people would have the free ability to search those decisions.
And my follow-up, Madam Chair, is the pool issue. What's your concept of the appropriate size of the pool? Because, we've heard some criticism that 9 is not enough. I mean, you people have been the police, you have policing collective bargaining in this state and have for years. And I'm curious what your idea of the pool should be.
Senator, I don't think that we can actually quantify that right now because we don't have an understanding of how many police arbitrations actually go on. That's one of the things that has been mentioned about having PERC as the clearinghouse for all of these decisions. That would give us a much greater understanding of how many police arbitrations are actually conducted on an annual basis. But if the pool is to be expanded, I don't think that we would have any issues implementing the provisions of Senate Bill 5055.
Great. Terrific to hear that. Thank you so much for being available. And if you could stand by for this next hearing as well.
Absolutely.
And I appreciate that. We're going to go to close the hearing now on Senate Bill 5055.
Kaiser, this is Susan Jones. I see Senator Honeyford has his hand raised.
Oh, Senator Honeyford, I didn't see it. Ah, there you are. Go ahead.
Thank you, Madam Chair. For PERC, I would like to see a copy of the curriculum you propose for training these people so they're properly trained in law enforcement issues. Thank you.
Excellent. Then let's move, close the hearing now on 5055 and move to Senate Bill 5134. And Jarrett, would you give us a staff report, please?
Thank you, Madam Chair, members of the committee. Jarrett Sachs, staff to the committee. Senate Bill 5134 relates to enhancing public trust and confidence in law enforcement and strengthening law enforcement accountability. The bill before you lists 23 types of revisions related to officer discipline and oversight that are prohibited from being included in collective bargaining agreements covering law enforcement officers. The complete list is on page 3 of your bill report. Examples of the types of prohibited conduct or provisions include requiring a waiting period before an officer is interviewed by their employer about a use of force incident, limiting secondary employment management, oversight, and policies established by the employer, limiting a chief or sheriff's authority to remove a law enforcement officer from duty or place an officer on leave, and limiting the authority, composition, or responsibilities of a civilian oversight entity. The bill also provides that discipline of law enforcement officer misconduct is not subject to arbitration and that appeals are subject to a civil service commission, administrative law judge, or a hearing examiner. The bill also establishes qualification requirements for civil service commissioners, ALJs, and hearing examiners that hear appeals. The decision of the employer must be upheld and the discipline cannot be reduced by a civil service commissioner, ALJ, or hearing examiner unless the decision of the employer was arbitrary, capricious, or based on an illegal reason. The bill also establishes requirements, including timelines for appeals of discipline for misconduct. For example, appeals hearings must be open to the public and a written decision must be made available to the parties in the public. Additionally, the bill establishes a list of specific misconduct that must result in discharge of a law enforcement officer. Examples include use of excessive force, theft and misappropriation of funds, and commission or conviction of a felony offense. The bill also requires municipalities to establish procedures for receiving and investigating complaints of misconduct and imposing discipline on officers. A fiscal note was requested but not yet received, and with that, I'm open for questions.
Thank you, Jarrett. Questions? I see that Senator Solomon is here with us as prime sponsor, and Senator, would you like to present your bill?
Yes, thank you, Chair Kaiser. My name is Jesse Solomon. I proudly represent the 32nd District, that's North King County and South Snohomish County areas. I'm also a proud former member of SEIU Union. I was a public defender with King County, and it was great to be in that union. I also believe that the vast majority of officers are well-intentioned and provide a great service to this community. I support them in their efforts, and I condemn the attacks that we've seen on police and the violence against the police that we've seen lately. But we know that there are occasions where police violate their duties. And for those occasions, we have a broken and ineffective arbitration accountability system. The New York Times reports that over half of discipline cases that are arbitrated nationwide either result in lessening of discipline or reinstatement of fired officers back to the force. That also holds true in Washington State. Right now, appeals of discipline suffer from a conflict of interest in the sense that we use privately hired arbitration lawyers paid for in part under some agreements by the very police that arbitrators sit in judgment of in hearings that are closed to the public. This bill changes that by sending appeals to a civil service commission, hearing examiner, or administrative law judge who are not paid in that fashion and do not have conflicts of interest. The appeals process would be reformed under this bill to allow for transparency, and the hearings would be more open to the public. This bill does still allow for due process, and it does still allow for appeals. This bill does not support the wholesale elimination of collective bargaining as a labor relations process. It maintains collective bargaining for wages, hours, working conditions, but not for police accountability processes, which I don't think should fit under working conditions because of the broader public interest that's involved. We can pass bills to ban chokeholds or no-knock warrants and things of that nature, but if we don't change the accountability system, then those reforms could be rendered virtually meaningless when we try to hold officers accountable for violating those new rules. Current practice does not allow for responsive discipline to changing norms. The decisions are rooted in discipline of past practices, so that arbitrators often have to say, well, we understand that we have the Me Too movement, we understand we're trying to be more sensitive to racial discrimination, but we're bound by the decisions of the past where the punishment was much less because the seriousness, because we weren't taking it as seriously then. And we need to end that. This bill ends that. And in conclusion, we also need to stop the practice of letting collective bargaining agreements limit or prevent citizen and civilian review boards. This bill would accomplish that. Finally, I want to say this bill is not about union busting. This bill is about being responsive to the community. We have to have this reform. Thank you so much, Madam Chair, members of the committee.
Thank you, Senator, for bringing this bill forward. Senator Conway has his hand up.
Madam Chair, one thing that we forgot to do is have some staff analysis of this bill. So I just remind you of that need.
Thank you.
Thank you. Thank you, Senator Solomon. I've not.
Jarrett Sachs did present this bill. Is there some question you had for Jarrett?
I don't think Jarrett produced an analysis of the last bill, but not this bill.
I believe Jarrett went over the bill report with us. Jarrett, is there something I'm missing?
Senators, I think you did.
Yeah, I presented the bill. I didn't have a background because it was mostly the same background from the previous bill, but I summarized the bill.
Okay, we have the bill report also in our EDB and other documents. Any other comments? Okay, we are running a little tight on time and we have a lot more people signed up for this bill. So I'm going to ask you to be as brief as possible. I'm going to have a 1.5 minute timer for speakers, 1.5 minutes now. And I'd like to call Judge Ann Levinson, Council President Briggs again from Spokane, and Paige Fernandez. It's always a little slower with this technology, so that does eat up some of our time we'd like to have in testimony. If you have written testimony, please submit it to staff. Why don't we start with you, Breen, Commissioner, Council Member, President. I see you. Go ahead.
Thanks so much, Senator, again, for allowing the time, and special thanks to Senator Salomon for bringing this forward. I'm Brian Beggs. I'm Spokane City Council President, and I also, just by way of background, have been a lawyer almost 30 years and have engaged in quite a bit of police issues. I've represented law enforcement who've been accused of misconduct and those that have accused them. And I think the strength of this bill is that it brings so many issues together that people have complained of over time, immemorial. And I think that's the strength. I agree with some of the people I've heard who are supporting that there needs to be more discussion about some of the specific things, but it really does cover the waterfront, so to speak. And I guess I want to point out that we have great police officers in Spokane and across the state, but I really reject the idea that they're bad apples. There may be an occasional person that really has a bad intent, but mostly it's policies and training that get in the way. And the whole policies around discipline are some of them. And you just heard a list of things that get in the way. So it's really important to look at them so that we get justice, because over time, some people who have suffered deaths and injuries of their family members, they just feel like the system is stacked against justice. And what this bill does is it looks at the whole historical context of how we got here and says, how do we move forward together, knowing that police work for the community and communities set the values and really the priorities, and police implement them. So we're long overdue to coming together on this. I think this bill is exactly the right discussion. And I appreciate Senator Salomon saying it's not about attacking officers or unions. It's about coming together. So I look forward to further discussion on this. And my one small thing, the automatic firing for any use of excessive force, I think that's one where we need to dive in, because if I was going to do that, I would do it for excessive deadly force, not just any excessive force.
Okay.
With that, thank you for your time.
Thank you. Judge Levinson. Good to see you. I can't hear you. Let's get you off mute. We're not getting you off mute.
I'm off mute on
There
my,
you are.
is that? Okay.
Yeah.
All right. Thank you, Chair Kaiser. It's great to see you. Thanks for addressing police accountability, disciplinary appeals, and accountability systems. I want to thank Senator Salomon for bringing this forward. And I agree with many prior speakers about the importance of these reforms to help address police violence. Since leaving the bench, I have helped governments and nonprofits work on a number of different types of system reforms. I worked with several of you when Representative Katie and I co-chaired the commission to redesign how we serve children, youth, and families in our state. And another area in which I've worked over several years has been police accountability. I've reviewed thousands of complaints and investigations of misconduct, dozens of police contracts, disciplinary systems, and consent decrees. I've made recommendations for strengthening policy, training, contracts, and laws. And I've seen firsthand how frequently families and communities don't get the accountability they should from the system that we have today. So I'm here today to speak in support of the many ways in which this bill strengthens police disciplinary systems and sets some standards for police accountability with meaningful, effective reform in which the public can have trust and confidence. When you all enacted child welfare and juvenile justice reform, you asked, are we serving children, youth, and their families as we should be? Are we getting the outcomes that impact lives for the better? And would we design the system the same way, knowing what we know today? When it comes to police accountability systems, the answer to these questions is absolutely not. It's the same answer we saw when we did that work, and it's why you all made such meaningful reforms in that arena. And I would encourage you to do the same thing here. We need to acknowledge that more accountability of the public is necessary and long overdue, that at the very least, our disciplinary appeals practices for police must be transparent, effective, mete out fair, impartial, and swift discipline commensurate to the wrongdoing, and help ensure that the civil and constitutional rights of the public are upheld.
Thank you, Judge. I'm going to ask you to wrap up.
All right, I will do that. I'll just conclude by saying that there are essential elements that should be included statewide in these systems. If we leave it in place as it is, or leave it subject to contract by contract, county by county, city by city, we continue to put the burden on families and those who are harmed instead of on us. Thank you very much for your consideration.
Thank you, Judge. Paige, welcome.
Good morning, Madam Chair Kaiser and members of the committee. For the record, my name is Paige Fernandez, and I am representing the American Civil Liberties Union as its National Policing Policy Advisor, testifying in support of Senate Bill 5134. First, I want to be very clear. Collective action is an important source of working people's and the labor movement's power. Workers, including police officers, should have the right to secure fairness and dignity at work, living wages, protection against discrimination, harassment, and safe and healthy working environments. But this important power can also be misused to undermine constitutional and just policing. Given the immense power of police in our society, it is of the utmost importance that we are able to hold them accountable. In 2020, 1,127 people were killed by the police across the country. 2020 protests in the wake of many of these killings showed us that the lack of police accountability for this harm is rampant, even in communities that continue to demand it. You can lead the nation here in what you do today. You have the opportunity to make a real impact in the lives of the constituents you represent. You have the opportunity to underscore the importance of police officers' ability to unionize, while also telling them that they cannot act with impunity when they harm the residents you represent. By passing this bill, you can ensure that police officers still enjoy all the benefits of being part of a union, while also ensuring they're able to be held accountable. Thank you for considering my testimony. I urge you to hold a vote and pass Senate Bill 5134.
Thank you, Paige. I see no hands up, so we're going to move on to the next panel. Thank you all. Larry Brown with the State Labor Council, John Searcy with Teamsters 117, and Shawnee Wheeler with the Joint Council of Teamsters. Should be next up. I see we're coming along here. There they are. We're going to have, I think, President Larry Brown with the Washington State Labor Council coming up first, it looks like.
Good morning, Senator.
Good morning.
Larry Brown here. Let me get my video open. There we go. Thank you, Chair Kaiser and Senator King, for the opportunity to speak with you today. My name is Larry Brown. I'm president of the Washington State Labor Council. I just want to say very quickly before I get started, I want to thank you all for your public service. It's a tumultuous time, and I profoundly respect and thank you for that public service. I'm here today to testify in opposition to 5134 because it attacks a fundamental tenet of collective bargaining, that workers, through their unions, negotiate a contract with their employers that can effectively enforce it. This bill puts all the power of discipline in the hands of police managers, the same managers who have all too often perpetrated the toxic elements of policing that have led to many of the problems you are all trying to address. Nothing in this bill acknowledges the role of police leadership, the chiefs and the sheriffs, and the training programs that have allowed these problems to persist. This is not systemic change. Indeed, this bill instead adopts the bad apple approach to policing, only acknowledging individual problem cases without addressing the leadership, training, or oversight of the policing profession. Fixing this problem is necessary, but undermining basic workers' rights is not the way. Better regulating the profession of policing is something the legislature should do, and our affiliated unions have called for that. But ripping into the basic notion of representation and due process is not the way. I know there are many other proposals out there today and in the days to come, and we look forward to these conversations. But this one, unfortunately, leads us down a path that we cannot go. Thank you very much.
Thank you, President Brown. John, I see you're up.
Okay, can you hear me?
Yes.
All right, I'll watch the timer very close and try to make time.
Thank you.
First off, thank you for allowing me to speak today. My name is John Searcy. I am a very proud Latino, principal officer of Teamsters Local 117, a vice president of the Washington State Labor Council, where I chair the council's Race and Labor Committee, and I have a lot of passion for this topic and reform. I'm testifying today, unfortunately, in opposition to 5134 as in its approach to reform. The main reason, just to get to the point with the timer staring at me, is that the idea that we're going to change systemic problems, including deep culture in our departments that foster these problems by laying the responsibility at the feet of the working people within the institution is a big problem for me. If it's this easy to take away rights from current and future law enforcement personnel, how safe and secure are the rights of working people in other sectors, private and public? This bill does not hold accountable nor encourage the management and leadership of these departments to foster reform of policy and culture. Instead, it undermines the accountability that collective bargaining agreements hold management to. This bill sends a terrible message to organized labor and working people everywhere that your rights of the worker are expendable if management of your institution is in flaw. Closing at 3 seconds, I'll skip that part. We have good officers that are knowingly entering these systems as internal reformers. We have Black and brown officers that want to enter these systems because of their experiences at the hands of police, pushing through cultures that don't want them nor want their comments of reform. We should honor, support, and protect them by showing them they are worthy of the rights workers have fought for years. Thank you for your time.
Thank you, John. Shawnee, welcome.
Good morning. Can you hear me?
Yes.
Madam Chair and members of the committee, for the record, my name is Shawnee Wheeler James. I represent Teamsters Joint Council as the Political and Legislative Director. Collective bargaining is the power of the labor movement. It is a source of power that has ended workers to secure fairness and dignity on the job. With decades of nonstop attacks on public sector collective bargaining and public sector workers, we are cautious that some would seize this moment to suggest that the problems lie within police reform, not within police reform, but within collective bargaining in general, ultimately resulting in weakening protections for all public sector workers. More than anyone, we believe a union must not be a shield for criminal conduct. Like all workers, it is important that there is a system of due process when wrongdoing is accused. It is absolutely critical that reform remains focused on addressing institutional racism, unconstitutional policing, and police violence. We cannot allow changes to law enforcement collective bargaining to become a stalking horse for those with an agenda to undermine all workers. Undermining collective bargaining while also looking at reform to bring in resources for mental health, housing, and education services will impact those workers to do their jobs meaningfully and effectively. For the broader change this movement demands. So we want to work with the sponsor of the bill to look at this legislation a little further to make sure that we're enacting and protecting collective bargaining. Thank you.
Thank you, Shawnee. All right, I see no hands up. So I'm going to move to the community and labor panel that includes Fred Thomas, Devin Connor Green, and David Parsons. Fred Thomas, I see, is coming. Devin, there you are. And David. All right. Would you like to start, Fred? Fred Thomas, would you like to start your testimony? Can we get him activated? I see him on the screen.
Can you hear me now?
I can, thank you.
Okay, great, thank you. Thank you, Madam Chair and members of this committee. I am the father of Leonard Thomas, who was killed by police in 2013 and support Bill 5134. I-940, the voters of Washington said they wanted transparency and accountability from our law enforcement agencies. Unfortunately, collective bargaining prohibits either from being possible and shields officers from accountability for misconduct, including excessive force. As an example, the officer who shot our son was given over a week to write his statement, with several texts between he and his acting chief, who was also the incident commander that night. Radio transmissions from that night, the word hostage or pseudo-hostage was heard once each, yet in his written statement, with the help of union lawyers, he uses those words 37 times. The same acting chief incident commander sat on a review board that deemed this shooting justified. Section 3 addresses this type of conduct. Now, with over 10 years experience as a union steward, I understand the importance of a strong CBA, but law enforcement's contracts go beyond wages and working conditions. They prohibit an employer from disciplining that is neither capricious nor arbitrary. It allows officers to engage in conduct that is contrary to the general moral acceptance, which is not beneficial for the public or fellow officers who have a moral compass. They also conceal any decisions made on discipline from public scrutiny. Transparency and accountability are paramount to Washington citizens, and we will have neither until we remove this discipline from contract negotiations. Thank you.
Thank you, Fred. I'm very sorry for your loss. Can you remind us, please, where the shooting, in what jurisdiction the shooting occurred of your son?
Well, it was done in Fife. The sniper was part of a Metro SWAT team that took in Pierce County, Milton. They had 29 police officers from, I believe, 6 different cities.
Okay.
That come together.
I remember.
Okay, thank you.
Thank you for reminding us exactly of what that incident happened, how that happened. And again, you have all of our sympathies. I'd like to call forward Devin Connor Green with Black Lives Matter.
Hello, can you hear me?
Yes.
Good morning, Chair Kaiser, Vice Chair Conway, members of the committee. It's great to see you all again. For the record, my name is Devin Connor Green. I'm the lobbyist for Black Lives Matter, Seattle-King County, and the Washington Black Lives Matter Alliance. On behalf of both, we want to thank you for the opportunity to testify today in strong support of Senate Bill 5134. We'd also like to thank Senator Solomon for his willingness to champion this issue and for the clear message being sent to the entire state, as well as this legislature, in giving comprehensive police reform the attention and priority it so rightly deserves this legislative session. It's long overdue. At Black Lives Matter protests, it is routine to see some police officers use excessive force in the name of crowd control, where peaceful protesters are beaten, tear gassed, and pepper sprayed. Too often, these officers cannot be held to account because collective bargaining rules that have been privately negotiated make termination and even discipline nearly impossible. By allowing disciplinary measures to be developed with civilian oversight and by replacing private arbitration with visible and accessible public hearings, this bill will shed light on a process that for so long has quite frankly seemed rigged against the members of our communities. This has resulted in the erosion of public trust. With increased accountability, however, that trust can begin to slowly be rebuilt. That is the context of this bill. It is not in a vacuum. It is a critical component of not just revisioning, but actualizing holistic community safety to protect and serve Black lives and all Washingtonians. Thank you.
Thank you, David. Now, David Parsons with UAW, are you on board? Yes, you are.
I am, yes.
Good morning.
Good morning. Thank you, Chair Kaiser. Thank you, members of the committee, for hearing these bills and allowing me to testify. For the record, my name is David Parsons. I'm the president of UAW Local 4121, which is the union for postdocs and academic student employees at the University of Washington. I first want to acknowledge and center the experiences of Mr. Thomas and others who have experienced the unimaginable. I myself am an organizer, a proud union member for over 20 years who has fought for union contracts, including strong rights and protections like arbitration, and I believe categorically that collective bargaining is a universal right for all workers. I also believe that the labor movement has been at its strongest when we're fighting to improve conditions for all workers, represented and unrepresented, particularly those most oppressed by corporate power and racism. I deeply respect the positions of my brothers and sisters in the labor movement, many of whom you've heard today, and I deeply appreciate the complicated task at hand for your committee. I think it's important to listen carefully to the lived experiences of members of our community and compare that to the substantial body of national research linking certain terms of police collective bargaining agreements to racist police violence. Extensive research by Ann Levinson, who I've had the privilege to learn from, the scholarship of Steve Rushin and others, show how these terms too often undermine community trust and send a message that law enforcement officers will not be held accountable even if they commit serious and even willful misconduct. SB 5134 will address this in multiple ways, and I'll submit my written testimony later for more detail on this. All of these changes are designed to increase accountability at the level of the individual officer, but at the same time, it is critical that we understand accountability holistically. Combating racist police violence means not just holding individual officers accountable, but fundamentally reimagining our system of public safety in ways that go beyond the scope of this legislation. Again, thank you very much for taking my testimony, and I'd be happy to be part of this discussion on an ongoing basis.
Thank you, David, and I appreciate you submitting your written testimony as well. That will be helpful. And I'm going to move forward to bringing back Mayor Jenny Durkin, also Commissioner Colleen Eckelhawk, and Candace Bach. They've all testified on the previous bill, but are signed up for this bill as well. And so I'd like to hear if they have specific comments for Senate Bill 5134 now. I see Candace is here.
Senator Kaiser, I understand that Mayor Durkin and Ms. Eckelhart are not in the meeting anymore.
Oh, okay. All right. They did both in their previous testimony make some comments about this bill, but let's go ahead with Candace. And let me bring up, since Candace doesn't need to be all alone, let's put James Mcmahon on deck as well with WASPIC, if that works. If James is still in the building, if it's called that. Candace, please go ahead.
Thank you, Chair, members of the committee. Candace Bach, representing the Association of Washington Cities, here in support of this bill, and would like to thank Senator Solomon for bringing this forward. This is obviously a much broader proposal than the one we just talked about under Senate Bill 5055, and cities are supportive of this concept of taking a broader look at how discipline for law enforcement is addressed and how that interplays with the collective bargaining requirements. We think that there's a lot of good provisions in this bill that are worthy of further conversation, further discussion in front of the legislature. In particular, this bill goes further handled and moving it out of the hands of an arbitrator to an administrative law judge or hearings examiner, even a conversation in terms of looking at overall accountability in our police departments, and again, creating a consistent and reliable system for officers. I think I'm having some internet connectivity, so I will just...
No interrupted. If you have anything in writing, though, it would be very helpful.
So I will, yes, thank you. I will follow up in writing. Appreciate the opportunity to testify.
Thank you, Candace. And James, are you on board here?
I am, Madam Chair.
Good, you are.
Okay, great. Again, good morning, Madam Chair, members of the committee. I'm still James McMahon, Policy Director with the Association of Sheriffs and Police Chiefs, here to testify other to Senate Bill 5134. Let me start first. I'll kind of work in backwards order of the bill. Sections 5 and 6 are sections that we outright oppose. And if the committee were to move this bill forward, we would ask that you simply remove those sections. Section 3 is one that candidly is very interesting to us. I've represented law enforcement executives before you all to the legislature for, I think this is my 18th year now. And if I were to have kept a list of those arbitration and grievance related things that our members have lamented about over the years, this actually covers a vast majority of those things. However, taken in whole, the sum of all of those parts seem greater than each of them individually. And it feels like Section 3, candidly, it just simply goes too far. We seek a more balanced approach so that the grievance arbitration process between labor and management truly is balanced and not tipped too far in one way or the other. Regarding Section 4, we are intrigued with the notion of allowing our officers only one avenue to appeal disciplinary matters within the agency. We fear, however, that our civil service commissions would simply be overwhelmed and they're not ready to take on this additional work. So we would like to slate that idea perhaps for future legislation, maybe even suggest a task force.
Thank you, James. I don't see, you did not sign up for discussion in the hearing of Senate Bill 5055?
I did, Madam Chair. I was the last one to testify.
I'm sorry.
We supported that bill.
I see that. Okay. Thank you.
Of course.
Now, that gets to one more panel, and then we have individuals also signed up to speak. The last panel, let me just double check. Yes, Theresa Taylor, Spike Unruh, Leanne Kuntz, and Dennis Lawson again. Theresa, I see you.
Hello. Am I on?
Yeah.
Great. Hello again, Madam Chair, members of the committee. I'm Theresa Taylor, the Executive Director of the Washington Council of Police and Sheriffs. In the face of nationwide tragedies and expressed public distrust, our members continue to respond to calls to help people stay safe, protect their rights and liberties, and uphold our state's laws. WACOPS is here today in opposition to Senate Bill 5134 because it harms workers. I'll be quick. In exchange for arbitration, peace officers cannot strike. The process holds management to a known standard and offers workers protection from political pressure and a rush to judgment. The binding arbitration process allows objective third-party decision makers to ensure laws, department policy, and labor agreements have been followed. Management doesn't always get it right. While there is no clearinghouse of final decisions, we know from experience that management prevails in about 50% of arbitration cases. This bill asks you, Madam Chair and members of the committee, to pick winners and losers. The legislature should not be in the business of creating second-class citizens when it comes to labor, employment, and due process rights. Please do not move this bill forward. Thank you again for the opportunity to address you today.
Thank you, Theresa. Spike, there you are.
Thank you, Madam Chair and the members of the committee. My name is Spike Unruh. I am the president of the Washington State Patrol Troopers Association. I am testifying in opposition to Senate Bill 5134. The Washington State Patrol Troopers Association does not support the stripping away of collective bargaining rights of law enforcement. Through collective bargaining, employees secure fair pay and benefits necessary and vital to the workers and families of our state. Labor unions through collective bargaining help solve workplace disputes and inequities in a way that is beneficial to all involved and maintains a relationship between the employee and employers. For uniformed personnel, collective bargaining does not stand in the way of meaningful police reform. In fact, Washington is already a national leader in police reform under its current collective bargaining statute. When an employer proposes reform that affects a mandatory subject of bargaining, the employees are provided an opportunity to provide input And when an agreement is reached, employees have buy-in. When an agreement is not reached, RCW 4156 provides uniformed personnel an expeditious way to resolve impasse without strike through mediation and interest arbitration. There has never been any decision in interest arbitration in Washington that has stood in the way of police reform progress. Senate Bill 5134 erodes these hard-won protections in our collective bargaining rights, and that is why the Washington State Patrol Troopers Association is opposed to Senate Bill 5134. Thank you.
Thank you, Spike. Dennis, welcome back.
Thank you, Senator. Committee members, thank you. Again, Dennis Lawson, President of the Washington State Council of Firefighters. First, let me start off by offering my thoughts to Mr. Thomas for the loss of his son. Again, it puts the importance of what we're talking about today, the loss of life, a grieving father, a grieving family is important, something we need to deal with. As I said earlier, we need to do better, we can be better as humans. Unfortunately, I rise in opposition to Senate Bill 5134 today, as it is currently put in place. The collective bargaining process has been established in Washington since 1967, where firefighters, police officers, and many others have enjoyed the right to bargain at the table, to sit down and express their concerns with management and come to some sort of resolution. As I read through the proposal, I noticed a number of limitations, items that were going to so to be tip the scale to the employer. As I also read through that, I noticed that many of those items could have and should have already been presented by a number of employers in the negotiation process. They're not illegal, they may be considered mandatory, but there's something that the employers should have and could have started on a long time ago. It's unfortunate that we find ourselves here at this point. We are willing to work with you, willing to find a resolution. And again, I just want to stress the importance of the loss of life, Mr. Thomas. My thoughts and prayers to you and your family. Thank you, Senator. Thank you, committee, and look forward to working with you all.
Thank you, Dennis. Leanne, go ahead. Go ahead, Leanne.
Thank you. Good morning, Madam Chair and committee members. For the record, my name is Leanne Kunze, and I proudly serve as the Executive Director of the Washington Federation of State Employees, representing over 47,000 public service workers throughout the state of Washington, including fully commissioned and limited commissioned law enforcement personnel. Our federation supports improvements in policing practices that promote safety and justice for officers and the communities they serve. However, this bill does not do that. We assume positive intent in the author's proposed language. However, the actual impact is an erosion of the very benchmarks of collective bargaining and employee rights, due process, fair treatment, and equal access to procedural justice. We completely understand the desire and duty to hold police accountable, just like other professions. But this bill essentially eliminates access to justice by eliminating access to reasonable due process when faced with career-ending allegations. This also condones a presumption of guilt until proven innocent, rather than the reverse. We trust the author's intent to reduce barriers to police accountability, but in reality, it only reduces barriers for police management accountability. Management is not and never should be the last word when decisions are being made about a represented employee's ability to continue in his or her chosen career. Arbitrators are professional and neutral fact finders. Reducing barriers to police accountability is a noble and necessary goal. There's nothing noble or reasonable about eliminating due process rights, especially to the degree proposed under this bill, and therefore we cannot support this bill as written. As a union, we champion collective bargaining and due process rights, including officers, while also advocating for reforms to confront systemic and individual racism. We must rebuild trust between police departments and the communities they are sworn to serve. This requires reconciliation and a commitment to unabridged justice, equal access to social, economic, and procedural justice. We ask this committee to reject this bill as submitted. We have also reviewed the other bill before you today, 5055. We find that it attempts to solve the same issues this bill addresses, but for us in a much less objectionable way. We want to be very clear on the record that we would stand strongly opposed to any bill that includes attacks on the collective bargaining rights and the rights of due process. Thank you.
Thank you, Leanne. I don't see any hands up for questions, so thank you all. I have on my screen Marco Monteblanco with the Fraternal Order of Police signed in wanting to testify, but I I'm just calling his name now to see if in fact, Marco, do you also want to testify?
Thank you, Madam Chair. Yes, I do appreciate the opportunity to testify again, members of the committee. My name is Marco Montalblanco, the president of the Washington State Fraternal Order of Police. I said my opening remarks during the last hearing, and so there's no need to save time. But one thing I did want to add is that policymakers should exercise caution if policy bills like the one we're seeing today with Senate Bill 5134 is directed at one particular agency, and the remaining agencies in the state get the feel of fallout. So put that in another way, we'd respectfully request that you not make such exceptions become the rule. Having said this, and knowing that the fraternal order police, we are a very solution-oriented organization. I think that has been proven in our body of work, that we try to find solutions and work with our communities and our legislators. This bill, we are opposing this bill today. This bill goes way too far into the particulars of collective bargaining rights of peace officers. Collective bargaining is the cornerstone of worker rights protections in this country. The legislature should, and we believe largely, refrain from getting too much between the worker and the employer's bargaining process. All in all, the bill represents bad public policy, does not recognize that the vast majority of peace officers do their job with honor, and virtually eliminates all bargaining rights of peace officers. We would respectfully ask that this committee focus on efforts on hiring practices, proper training, data collection, and independent investigations. And once these issues sort out themselves, and once bills like Senator Wynn's bill, Senate Bill 5055 take effect, we believe the policy this bill creates will not be necessary. However, we would or could potentially support a bill that simply says in one section that CBA provisions shall not violate state and local laws. Thank you.
Thank you, Marco. And I see you're from Kennewick. So one of the benefits of this forum we have on Zoom is that people from all over the state can more easily testify. I appreciate your participation today.
Thank you, Madam Chair.
So we have several people signed up individually, not representing organizations. So I will call them forward at this point. Shannon Chang, Amy Sundberg, Leslie Reed, and Kathleen DeSmit. So let's see where we're pulling these folks forward. I see Shannon. I see Amy. Let's get started with Amy, who's on screen, and I think she's unmuted. So let's go forward, Amy.
Thank you so much. My name is Amy Sundberg, and I'm a constituent from District 34. I am here today to express my support for this bill, which I believe is an important piece of legislation. I live in Seattle, so I'm going to be speaking about Seattle specifically. Here in Seattle, we've been struggling for quite some time to create a strong and fair accountability system for our police department. In 2017, our city council passed a police accountability ordinance that was hailed as historic and seen as a concrete step forward towards a stronger police discipline and oversight program. However, the next year, the SPA contract adopted was allowed to supersede and change many aspects of that ordinance. So what ended up happening for us here in Seattle was that people here thought we were going to get a fair accountability system. Instead, we ended up with only the appearance of one. That's why this bill is so important. It would change the law so that procedures by which law enforcement officers are disciplined for misconduct are not subject to collective bargaining, but would instead be determined through public processes. With legislation like this in place, we'd have a much better chance of negotiating fair contracts with our police unions. This would increase public trust in the police department, a trust that has further eroded, unfortunately, from police behavior during the protests this last summer, and a trust that we as a community desperately need to start rebuilding. And Seattle isn't alone in the struggle for increased transparency and accountability. This approach will bring consistency and increased accountability throughout the state. So I'm urging you to consider this bill really seriously and consider passing it out of committee so we continue to make progress. Thank you.
Thank you, Amy. Leslie Reed, I see you're also up and ready to go. So let's get going. Thank you, Leslie.
Good morning. Good morning. My name is Leslie Reed. I'm a constituent of the 43rd District. So because I'm nervous, I'm going to read this. Police officers carry the responsibility of caring for people's lives, and intervention is often a matter of life and death. The collective bargaining that has ensued in the past allows officers to use their enormous capabilities with no accountability. This has created horrific consequences, the burden of which has been put on the victims. Law enforcement has no incentive to stop and think because they know they will not be questioned. This bill begins to address the separation of accountability from contract negotiations by not allowing the contract between police organizations and their employers to supersede community regulations that pertain to holding officers accountable. There's a chance that officers will pause before causing irreparable harm. Thank you.
Thank you, Leslie. And Amy Sundberg, I believe, did we just have Amy up? No, we haven't. Okay, Amy, no. Now I see Shannon is up. I'm getting very confused at my old age here. Shannon, go ahead.
Hi, thank you. Greetings, Chair Kaiser and esteemed members of the Labor, Commerce, and Tribal Affairs Community. Thank you for the opportunity to provide testimony in support of SB 5134. My name is Shannon Chang. I am a local police accountability grassroots activist in Seattle from District 36. Despite a federal consent decree, passage of a city accountability ordinance hailed as landmark, and continual engaged community involvement and advocacy, we still have a broken system where serious officer misconduct against civilians routinely goes unpunished. After working on the issue at length, I have concluded that local jurisdictions do not have the authority to impose discipline and thereby affect the culture of our local police departments. In cases where serious infringements of civilian life and liberty have transpired, our police chief, our mayor, our city council, our accountability bodies have not been empowered to serve justice. As a result, public trust in our law enforcement continues to erode because without accountability, there cannot be healing. I am testifying here today to ask for your help. This bill is not about eliminating collective bargaining rights for law enforcement officers, but that police accountability for serious misconduct should not be subject to collective bargaining. It is critical for the overall reform effort that local jurisdictions have agency in ensuring compliance with the standards we set. Please pass SB 5134 out of committee. Thank you.
Thank you, Shannon. Now I have still Kathleen DeSmit, who did sign in, but apparently has left the Zoom meeting. Are there any other members of the public who signed in and who has not been called? All right, I think that will complete the public testimony for this hearing on Senate Bill 5134. I want to say I am very impressed at the participation of so many people in this hearing today. We had over 106 individuals sign in on both sides of both bills. And that's terrific. Civic participation is a very difficult topic. We are going to have some hard work ahead to find our path forward, but I'm confident we will find a path forward. This is extraordinarily important to our communities, of all of our communities, and let's all work together in good faith to come to some path forward that we can agree on.
Senator Kaiser, Senator King has his hand raised.
Great. Senator King, would you like to make a comment as well? I need you to unmute, Senator King.
Thank you, Madam Chair. I thought the meeting went very well and appreciated the way everyone testified and all of that. I do have a question in regards to what I think could be an issue. When we have our meetings in our committee meeting rooms, we do not allow signs. And so I've seen this twice now, and I'm not trying to pick on Ms. Kunze, but there was a sign she had in her background that would not, and I'm not picking on it because of what the sign said, you know, because I can assure you that if we allow this, there will be others that will add signs that some of you may not agree with. So I'm wondering if we need to establish a policy that the background should not include signs that are trying to make a certain point, because we wouldn't have allowed them in our committee meeting rooms. So I just bring that up as a point to think about. So I think that needs to be determined. So
Thank you, Senator King. I appreciate you bringing that forward. It's an interesting thought. These unusual times when we're on these Zoom meetings and people are joining us from their homes, they might not even remember what's on
well,
their
no, and I yes, I'm
Yeah.
not, as I say, I'm not trying to pick on her,
But
but
it's
it's an issue that I think needs to be addressed. So thank you,
It's an
Madam.
interesting point for us to consider, and let's urge as a policy that individuals try to refrain from having placards or individual signage for their testimony. Not to mention, we always see people with their T-shirts that
Oh,
have their own signals. So
No, that's right.
anyway, any other members have a concern or comment they'd like to express at this point? We have about 2 minutes, well, 5 minutes left to go before we're actually cut off. Excellent. I really appreciate all your participation today. We have a lot of work to do ahead.
Senator Kaiser, Senator Conway was raising
I
his.
saw. Senator Conway.
On Senator King's comment, I don't think a sign designating what organization you're working with is a problem, and so I believe that slogans would be an issue here. But you know, so many of us, if we look at our signs that we have, we identify ourselves as senators and members of the legislature all the time. So I just ask that when we look at this issue, we consider that some of these people are working representing organizations. So I hope that we don't narrow it so badly that you can't have any sign at all. So I just add that comment. So thank you.
Yeah, I don't think we'll have a firm rule, but just a little guidance might be in order. Personally, I like blooming cherry trees. So that's my choice. I hope you all have a good day. This concludes the hearing today for the Labor, Commerce, and Tribal Affairs Committee. Thank you all for participation. We are adjourned.